Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled Attorney General Concession on Appeal. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, I would like for you all to hit that like button, and also, if you're new to my channel, hit that subscribe button, and also hit that notification bell so you all can be notified as I'm dropping these powerful videos. So without further ado, let's get to it. Okay guys, so what we have on the screen is in fact a document that my ARC received from the Office of Attorney General coming out of the state of Texas, okay? The upper right hand corner, text in blue, that is in fact letting him know that this document was in fact accepted in the 5th Court of Appeals coming out of Dallas, Texas, okay? The date of this document was filed on July 24th, 2024. As you all can see in the file stamp below it, it states what? Filed in the 5th Court of Appeals, Dallas, Texas, 7/24/2024 at 3:20 p.m., right? Filed with the clerk of court. So again, in the middle of this page is in fact the seal of the Texas Attorney General, and the date of the letter is July 24th, 2024. And this document was in fact e-filed and sent out USPS to my ARC, okay? So now as you all can see, that is the clerk of court for the 5th Court of Appeals information. Okay, the reason for this letter is pertaining to what? The Court of Appeals case number, which I also crossed out, and the trial court case number, which I also crossed out, styled in the interest of the minor child, whose name I also crossed out. Then it states, Dear Mr. Morin, 1. Partial concession. What is a concession, guys? Hold for one quick second. Let's go there so we can get what a concession truly is. Alright, so now, as you all can see, we're coming from dictionary.findlaw.com. Let's read the definition for concession. Concession is in fact a noun. 1. An act or instance of conceding or yielding. Then it states, something conceded as A. Acknowledgement, admission. That's all it is, guys. They simply acknowledge or admit to their wrongdoings, guys. So they conceded to their wrongdoings that will happen in the case, which that means that the case now have to be again dismissed, okay? So now let's go back and continue reading the letter that was filed to the court of the concession pertaining to my ARC's case. Let's go back there. Okay, so now, as you all can see, let's pick this back up at the top where it states, the Office of Attorney General concedes error on one point of this appeal. Then it states what? The reason why. So highlighted in red is in fact the reason why they concede on the appeal. And it states, insufficient evidence to support the rendition of an order affecting the parent-child relationship and a child support obligation. You see, guys? That's why, but we're going to continue to read the order because the Attorney General will also go into detail so you're going to get a better understanding of what's truly going on here. And it states what? Although co-appellee, who is in fact the child's mom name who I crossed out, that's why they got it in parentheses stating mother, provided general testimony attached to the UIFSA, that stands for the Uniform Interstate Family Support Act, petition. This testimony was never entered into evidence, and no other evidence was provided concerning the child's parentage. As such, there is what? Insufficient evidence to support the finding of a duty of support between appellant and the child of suit. So again, guys, we stopped them right then and there. Even though the lower courts, guys, when I tell you all, the lower courts are breaking the rules, they are not following their own rules, but you have to keep applying pressure, okay? You have to keep going forward. Don't stop until you get the remedy that you desire, okay? So now this is page 1. Let's go to page 2. Let's continue reading. Let's go there. Okay, so we on page 2.2, and it reads, OAG acknowledges that mother's general appearance was not introduced into evidence. So when it says the OAG acknowledged, that means what? The OAG agrees that what? That the mother's general testimony was not introduced into evidence. But let's continue on. The OAG filed a suit affecting the parent-child relationship under the Uniform Interstate Family Support Act. Appellant was served with citation and petition on October the 22nd, 2020 in Dallas, Texas. Appellant filed an answer on November 4th, 2024. Why did I highlight that in red, guys? Because in Texas, an answer concedes as what? As an appearance. So let's go there. Hold on. So it states clear as day, guys, that what? Appellant filed an answer on November 4th, 2024. So now let's go there real quick. One quick second. Let's take a detour real quick. Okay, so now, as you all can see, we're coming from casetext.com. Let's go over Texas Rules and Civil Procedures 121. And it reads, Rule 121 is what, guys? Answer is appearance. Okay, so basically, once you file your answer into the court in Texas, that's like you made a general appearance, okay? But now, let's read it. It states what? An answer shall constitute an appearance of the defendant so as to dispense with the necessity for the issuance or service of citation upon him. So again, guys, the courts like to say if you file an answer, then you waive your jurisdictional challenges, which is simply not true, guys. It's the nature of the answer, okay? If you file in your answer and your answer is challenging jurisdiction, then it's on the plaintiff to prove that, and it's just that simple. Don't let anyone tell you guys anything different, okay? These courts are wicked. They like to be slick, okay? So now let's go back to the concession letter that the Attorney General admitted to in the court. Why? Because the Attorney General simply know this, but they try to play as though they don't until you hold their feet to the fire. Continue to apply pressure. Don't stop. Don't quit. We have to do what we have to do. So now let's go back to the letter and let's continue on page 2. Let's go back there. Okay, so now we're back at page 2. Let's pick it back up at the top where it states, 2. The OAG, again, acknowledges that mother general testimony was not introduced into evidence. OAG filed a suit affecting the parent-child relationship under the Uniform Interstate Family Support Act. Appellant was served with citation and petition on October the 22nd, 2020 in Dallas, Texas. Appellant filed an answer on November 4th, 2020. My bad, guys. Last time I read, I said 2024. My bad. I meant November 4th, 2020, not 2024. Okay, that's why I had to make that correction. But let's continue on. Then it states the OAG's UIFSA petition attached mother's general testimony that asserts the child of suit was born during her marriage to, who's my aunt name, who I crossed out, who was in fact the what? The appellant. Then it states an initial order was obtained on November the 12th, 2020. However, the order was what? Subsequently vacated on September the 29th, 2023. For those who have been following me, go back to my videos back in September 29th, 2023. You all will see that we in fact got that order vacated. So after we got that order vacated, they try to come back out to him again in 2024, and we whooped them again, guys. But let's continue on. Then it states, following appellant's petition for bill of review. The order was vacated because the record did not reflect that the appellant was provided notice of hearing. So now, it clearly states that what? The order was vacated because the record did not reflect that appellant was provided notice of hearing, right? So, back in 2023, September 29, 2023, they tried to say that I did not provide notice of hearing. But up here, the first paragraph, it states what? Highlighted in red. Appellant filed an answer on November 4th, 2020. As we read in the Rule of Civil Procedures for Texas, Rule 121, it states what? If you file an answer, it represents an appearance, meaning that what? They try to concede that you're being served. But the third paragraph said that it was vacated because he wasn't served. But if he filed an answer, that means what, guys? If it's supposed to be a general appearance, that means that even though you filed an answer, it cannot be considered a general appearance unless you do not challenge your jurisdictional challenges, or you do not preserve your jurisdictional challenges once filing an answer. And it's just that simple, guys. But let's continue on. It states again, fourth paragraph, a new trial was held on February 21st, 2024. Counsel for OAG attempted to conduct a direct examination of appellant. However, appellant refused to what? Answer any questions. Okay? Highlighted in red, guys. Let's continue on. Including what? Questions as to what? How he knew mother. Further, although appellant insisted he wished to challenge personal jurisdiction, he refused to answer questions as to whether he was a resident of Texas. Get understanding, guys. Highlighted in red is your remedy. Right there for the whole world to see. But let's continue on. It states, during the hearing, counsel for OAG asked the trial court to take judicial notice of the Uniform Interstate Family Act petition and mother attached general testimony. Highlighted in red, guys. This testimony would have been admissible pursuant to section 159.316. Okay? So now we're going to go to page 3. As you all can see, this is in page 2. Let's pick it up at page 3. Let's go there. Okay, so now as you all can see, we're on page 3. Let's pick this up at the very top of the Texas Family Code. However, the general testimony was never formally offered or entered into evidence. As such, there is no evidence on the record that the child of suit was born during mother's marriage to appellant. In family law cases, the abuse of discretion standard of review overlaps with traditional standards of review. As a result, legal and factual insufficiencies are not independent grounds of reversible error, but instead are facts relevant to our assessment of whether the trial court abused its discretion. To determine whether the trial court abused its discretion, we consider whether the trial court has sufficient evidence upon which to exercise its discretion and error in its exercise of that discretion. So again, guys, because the trial court entered an order without the evidence even being in favor of the child's mom, they just simply entered the order because they felt like it against my aunt. That was in fact the error and also an abuse of discretion. Why? Because there is no evidence before the court of anything that they was claiming. To further prove that, let's continue on. In this case, no evidence was offered in support of the presumptions of paternity under Texas Family Code Section 160.204. No other evidence was offered as to the parentage of the child of suit. Because of this, the trial court abused its discretion in entering an order finding a legal duty of support between appellant and the child of suit. So again, guys, the trial court clearly abused its discretion, and because the trial court abused its discretion, this order must be vacated. But let's continue on. It states, although there was no testimony concerning appellant's net resources, the trial court set support pursuant to child support guidelines for obligors earning minimum wage. So again, guys, there was no evidence on testimony on how much he even got paid. But yet they still set his income at minimum wage. They don't even know if he have income or not, let alone try to set it at any amount. But let's continue on. In the absence of income evidence, Section 154.068 of Texas Family Code allows trial courts to presume. Now, guys, let's go to page 4. If you all would like to read the footnotes, simply pause the video and read the footnotes. But let's continue on. Let's go to page 4. Okay, so now we're on page 4, which is the last and final page. Let's pick this up at the very top, and it reads, the party has an income equal to the federal minimum wage for a 40-hour work week. 3. Reiteration of concession. Based on the foregoing, the OAG concedes, as the face of the record demonstrates, that there was no evidence introduced to support the finding of a legal duty of support between appellant and the child of suit. As such, the order of March 9th, 2024 should be what? Highlighted in red, guys. Vacated. So again, guys, this is what remedy looks like, okay? It's a beautiful thing when you have the Office of the Attorney General ruling with you. As you all can see, it was signed by the attorney for Child Support Division, right? And she CC'd my ARC below, page 4, okay? So again, guys, this is what remedy looks like in Texas, okay? Just don't take no one's word for it. I can care less if they bring somebody else on there saying that they have received remedy. If they haven't showed documentation, guys, do not believe them, okay? Everything is not what it seems online. There's a lot of people on here lying, guys. They don't know what they're doing, and they're just coming on here pretending it's such. And it's just that simple. It's a sad day, guys, but again, as always, we've been applying pressure since almost 7 years now, and we're going to continue to apply pressure. Remedy after remedy, 7 straight years of testimonies. Let's keep it going, guys, for 7 more years, however long I decide to continue to do this. But look, you all be blessed out there, okay? If you all need my help, hit me up in my email at y'allismagnified@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. More testimonies coming in the near future. With that being said, you all be blessed, and I say shalom.